Hi, my name is Mike Rikowski, estate planning and elder law attorney here at the Rikowski Law Firm. What are you doing in here?
Hey Dad, you're in my chair.
In your chair? I'm not giving up my chair.
Welcome to the Rikowski Law Firm.
All right, Michael, we've talked a lot about power of attorney in terms of what the difference is between power of attorney and guardianship, when you would need one or the other. And now let's help people actually go do the thing of getting that power of attorney so that they don't end up in probate court having someone else be decided on who's going to be their guardian. So how can people if they're on their own and they want to figure this out themselves, what are some tips and tricks to get them started?
I think the importance of this is always overlooked. In estate planning, we're always so focused on who gets my stuff, but really to help yourself, get your power of attorney in place. Because I've just seen so many bad situations related to not having a decision maker in place. Okay, so how can we do this ourselves? So there's lots of websites. The list is endless, of all these websites that can help. Actually, most states have a statutory power of attorney. So you can probably find that too. And then it complies with your state's rules. So go look for an online form. I'm not saying that they're the worst, but here's what's really, really important, because what I found in my experience when I've seen documents, powers of attorney that individuals have done prior to engaging us to help, is it's not so much the what's in the document, it's what they did in filling it out that made it bad, unusable. And the unfortunate thing is they won't know how bad it is until they try to do it when they don't have the ability to make decisions, and now it's too late to do a new one, right? So here's some really important things. When you're doing a power of attorney, remember there's both a financial and a medical power of attorney. They should never be combined. So you need two separate ones. That's one thing that I've seen that's been bad, is when somehow a form got combined. You need a separate financial durable power of attorney. The word durable means it works after you become incapacitated. And then you need a healthcare power of attorney. Going forward, you need to appoint an agent, who's going to make decisions for you. And you also want to appoint successor agents just in the event that person is unable to act for you because they've passed away, they're incapacitated themselves. But the first decision you need to make is this document springing or immediate? And what that means is does this document work the moment I sign it, or does it work after someone declares me unable to make decisions for myself? Typically, that's two doctors. So that's the first decision you need to make. Is this document going to be springing or immediate? Then when it goes through the powers, so look through everything. If you're doing this to have your spouse be your agent or your kids be your agent, just give them everything in the kitchen sink. Let them step into your shoes, because financial institutions are so picky on what the powers say and everything. If you exclude some things, it's just going to cause problems. So if it's family, just let them do everything. But here's what becomes important, is the execution of the document. And this is where I see a lot of times it goes wrong. What I would do if I were you is just have it both witnessed and notarized. Every state has its own requirements about whether it needs to be witnessed or it needs to be notarized, but it's never going to be invalidated because you did too much. Does that make sense? For sure, I've seen them invalidated because it was just witnessed and it wasn't notarized, or it was notarized and it wasn't witnessed. Just have it notarized by a notary and witnessed by two uninterested parties. And what that means is you can't have your wife notarize it, you can't have your kids, you can't have your relatives notarize it. Who you can have is the garbage man walking by. You can actually grab that person. It just needs to be an uninterested party. So have two uninterested witnesses and a notary. Final thing. The power of attorney has to accept their responsibility. They don't need to do this till they're actually acting, but there needs to be acceptance pages. Usually they're the last pages of the document that say, I, Bill Smith, am willing to act as power of attorney for Mary Smith. And so that person needs to be able to accept and sign. You have it properly executed, put all the powers in there, and then have the acceptance pages there available so that someone can act for you. I think those are the biggest mistakes that I find, is just is just in the execution of the form itself.
And I think something that's important to note that I know you've said in previous videos, but just it's so topical here, is the importance of understanding that if you do not have this document in place, that doesn't mean it automatically goes to your next of kin or to your wife or significant other. I think that's also a common misconception, is that you don't need this because it's just going to go to them. And actually,
it's a big misconception that people think a spouse can automatically act for them, that family can do that. And that's not the case at all. Every state has a statute for order of priority of who would act for you. And for whatever reason, it doesn't seem to ever make sense. It's never just like spouse and then kids, like we would all think it should be.
You're welcome to go, as Michael said, do this on your own. If you would rather our support, we are here to help. Please give us a call at 248-955-2842. Again, that's 248-955-2842. And we're here to guide you every step of the way. And if you want to keep learning about the ins and outs of estate planning, be sure to subscribe now and take your first step towards peace of mind, because estate planning isn't just about documents. It's about protecting your family and securing your legacy. Until next time.
See you guys later.